This is part 2 of a series of 3 short videos concerning discrimination. Part 2 looks at disability discrimination. Information given in this video is of a general nature. Employers should always seek specific legal advice about the issue they are dealing with. So here is a typical question about disability discrimination. How do I manage an employee that has a disability? What reasonable adjustments do I need to make? Sound familiar? I expect so. Quite a lot of my clients will be asking this question and will do so quite frequently. So the definition of disability. You're disabled under the Equality Act 2010 if you have a physical or mental impairment that has a substantial and long-term negative effect on your ability to do normal daily activities. That's the official definition of disability. What do we mean by substantial and long-term? Substantial, according to case law, is more than minor or trivial. For example, it takes much longer than it usually would to complete a daily task, like getting dressed. Long term normally means 12 months or more. For example, a breathing condition that develops as a result of a lung infection. There are variations to this, so I want to draw out the mental health and fluctuating conditions, because this is something that is less understood when it comes to the long-term effect. So a person that manages their disability with medication is regarded as disabled if they would experience the symptoms if they stopped taking the medication. That bit is more understood. But further to that, if the symptoms come and go and there are periods of wellness, the time period of usually 1 year or longer is not necessarily consecutive. So when it's a fluctuating condition, ill health may be shorter episodes over a longer period of time, lasting 12 months or more. For example, an employee may suffer with depression. They might manage their depression with medication. He or she may not have had any time off for a couple of years, so ordinarily that wouldn't count as long term. Recently, an event triggered a new period of depression and he or she has been signed off work sick. As this employee has a history of depression, they are likely to be regarded as disabled for work-related purposes, because of those fluctuating conditions stretching out over a longer period than 12 months. So let's think about the duty to make reasonable adjustments. Now, that's something that I'm asked about a lot. This applies when a disabled person is at a substantial disadvantage compared to somebody that is not disabled. And just to be clear on that, the duty to make reasonable adjustments only applies when it comes to a disability. It doesn't apply to other protected characteristics such as age or gender, etc. So some examples here of a reasonable adjustment might be to change or remove physical features or provide a reasonable alternative. It might be to provide auxiliary aids or to change a provision criteria or practice. An adjustment should, as far as is practicable, remove or reduce any disadvantage faced by a disabled person. Reasonable depends on the circumstances and may be different for different employers. And what would be looked at is how effective the change will be, how practical it is to make that change, Sometimes it's acceptable to consider the cost, particularly if it's hugely expensive, but in association also with what financial support might be available. The disabled employee may be able to access grants to facilitate their continued employment. It's also necessary to consider the size and the resources of the organisation. So what is reasonable for one business may not be reasonable for another business because they are much smaller, they have less money available and fewer resources, etc. The test of what is reasonable is objective, and it's not about what the manager personally thinks. So it's really important to speak to the agencies available or to take legal advice so that these issues can be properly assessed. So let's have a look at a couple of examples then. Thinking about a physical disability, an employee maybe permanently walks with a walking aid. So what can we do for that person as a reasonable adjustment? Maybe we could locate their working space on the ground floor. Perhaps that working space could be close to facilities such as the toilets in the canteen area. If that's not possible, a reasonable adjustment might be to allow that person extra time to get around, to walk around the building, to get to the toilets, to get to the canteen, and to get between different office spaces or different areas. And that wouldn't count against them necessarily when it came down to managing their performance. Thinking about mental health disability, which is more complex, an employee is off sick with anxiety and depression. It's important to take the time to really understand what's going on for them. What's causing them to be unwell? Is it work related? What support can we offer them? How can we help them get back into work, to come back in off their sick leave? Maybe we can reallocate some of their work so that they are not feeling so anxious. Maybe we can offer them more training if it is work related and then they're just lacking confidence. Could be that they want more frequent one-to-one meetings with their direct line manager or supervisor, and maybe just have the confidence to be able to approach them. So it's necessary to assess if all of those things are reasonable. If they're not, if it's not going to help or we can't do that, then maybe it could be that we are more flexible with their attendance. So maybe our absence management policy needs to be reviewed for them. Perhaps, being a bit more flexible around those triggers that would trigger the need to have a formal disciplinary hearing with somebody who's taken lots of time off sick. So we might also look at offering manageable workloads. We might want to explain how and where to get more support from. And we might be thinking about possibility of going down the capability route, disciplinary route, if it got to that. But that has to be a last resort, of course, and we need to consider other ways of continuing with their work. So we do need to be seen to be doing what we can to facilitate their continued employment before considering dismissal. That brings us to the end of part 2 of the discrimination videos. We've covered part 1, which is defining what discrimination is and the different types of discrimination, direct, indirect, etc. In part 3, I'm going to be looking at how to defend a discrimination claim, or maybe how to lawfully discriminate. And we'll be covering things like the genuine occupational qualification, proportionality, legitimate aims, etc. If you want more information about disability discrimination, contact me on the email address there, hello@contracthrm.co.uk. You can contact me via the Facebook page or via the website. So thank you for listening to part 2. I will see you on part 3.